Now, the Constitutional Court recently ruled that those involved in a gang rape can be considered guilty of rape, even if they themselves have not physically raped anyone. Now, the judgment stems from an incident that took place 21 years ago when a group of men went on what the court described as a rampage, which included the rape of 8 women, now the youngest of which was 14 years old. Joining me in studio right now is legal expert Lerato Pasha, who's currently writing down some details for me as well, but also practicing advocate. Carry on with the introduction there.
I wouldn't call myself an expert just yet. But yes, I am a practicing advocate. I'm an advocate of the High Court of South Africa, but I'm also in-house counsel at the Center for Applied Legal Studies.
Thank you for your time today, Lerato. Let's get down to this landmark ruling on Wednesday. There was divided opinion on whether people that had taken place or been that had been on the fringes, I guess, of a crime such as a gang rape of this nature, but had not physically raped anyone. There had been divided opinion on whether a person could be charged and convicted, rather, of rape. What finally settled the minds of these Concord judges in this instance?
Well, I'd say, I mean, a lot of the submissions that we made as the friends of the court really sort of swayed the opinion, if you look at the judgment. But before I discuss that, let me just say this was not just my doing. I had co-counsel in the matter, Loiso Mngandi. We were both representing the Center for Applied Legal Studies in the case. And the Commission for Gender Equality was also an amicus in the matter. So I would say jointly we managed to put submissions to the court that really were of significance and that really helped the justices. So if you look at the judgments, it's unanimous. It's 3 judgments concurring. The 2 are concurring really what the first judgment says. So from the judgments itself, the Constitutional Court was convinced. So there was no debate from their side, although I'm sure they had to vigorously speak about the matter before they made these judgments. What we said as the Center for Applied Legal Studies really was that the true nature of harm of rape must be understood. That rape is beyond penetration, and it's a crime really that affects so many of the constitutional rights that are enshrined in the Constitution. And those rights are stripped away in the process of rape. We wanted to make it understood by the justices and the public at large, I suppose, that really it is a crime of power. And to that end, exactly that, Judge Matopo wrote that, you know, exactly that rape is not primarily a sexual act, but also that in instances of group rape, as in this case, the mere presence of a group of men results in power and dominance being exerted over these women victims. Now, why has it taken the justice system this long to get to the point where, in many instances, in terms of our civic engagement and conversation, we talk about those dynamics, those social dynamics of power and group influence, right, over women in these settings. But why has it taken up to this point for a consensus to be reached in this matter? We sort of have a very conservative justice system also. But remember, courts like the Constitutional Court are not going to Meremun to make a decision like this. That a case has to come to the Constitutional Court.
Absolutely.
So firstly, the court has to have jurisdiction, and it's taken particularly this matter from 1998 to get to this stage, because there was a decision from the High Court that the other, well, accused and convicted members of that gang actually accepted it. Some tried to appeal, and when the appeal didn't succeed, they let it go. It's only until Petu applied to the SCA, and the SCA found different, that Shabalala felt, well, I was part of the same group. If Petu could get away with it, perhaps I should also apply to the Constitutional Court for leave and then be given an opportunity so that I could also escape liability. Now, we needed the court, if I may just clarify, to give parity in the law, because there had been conflicting judgments from different courts, not from the Constitutional Court itself per se.
Now, in wrapping up, what is ultimately the message to the public, to would-be offenders at large, the idea that you can no longer be an innocent bystander, right? The phenomenon of standing by and watching crimes, specifically rape, happen is an excuse. You literally have no excuse in the court of law.
Well, unless you actively distance yourself from the commission of crime. So we literally were saying, I mean, it's been too long. Too many people say it's not my problem, it's not my doing, and even if in one way or another they did participate in the assistance of the commission of crime, meaning even if they had common purpose and had the intention, people used to believe that if I did not penetrate the victim myself, I'm not guilty.
Yeah.
What the law says now is if you actively participate in a rape, whether you were holding a phone or you were tying the victim down or you were standing by the door or you had the gun, you do not have to penetrate the victim to be found guilty of rape if the matter goes to trial and all the elements are present.
All right, thank you so much for your time.